All right, welcome everyone. This is the June workshop of Central Baptist Church Economic Development Division. So happy to see all the smiling faces out here this weekend, and we have obviously a special treat. A lot of good information today. For the session, we have been talking about a lot of things as regards to home ownership. We've been talking about credit, just understanding your credit. And we have been talking about estate planning, budgeting. We have a series of workshops going on. And so this one is going to be a great one. We have our very own sister, Marche Stevenson Esquire. She's an attorney. She specializes in estate planning, and she's going to give us a lot of great information about estate planning. It's a lot of things that we need to know. How many of you guys know where your will is? How many of you guys know what's going to happen, when you die? I mean, we're all going to have to transition at some point, right? So we need to make sure we have all that information. I'm going through that myself, as well as with my father, to make sure that he has all his information in order. So definitely, this is going to be a great show. We have a series of events. Where can we find those events, Minister Dawn, about the sessions we have coming up? Mm-hmm. Mm-hmm. Okay. So you can find out the dates for the other sessions that we're doing at cbcgnc.org, as well as the Facebook page for Center Baptist Church. You can get all that information as well. So without further ado, I just want to start us out, lead us in prayer. And then the next voice you hear is, again, our very own Sister Marche Stevenson. So let's go to God in prayer. Dear Lord, I'd like to thank you for this beautiful day, Father, to come and learn about how we can better prepare ourselves for when we transition to your kingdom. Lord, we just thank you right now for all of the blessings that you've given us in terms of resources here at this church so that we can get the word out and let people know what is possible, Lord, and what they need to do in order to get their affairs in order. Father, we just ask you to speak through and use Sister Marche and be able to deliver the information that is needed. We just ask you to be with the audience, Lord God. Allow the questions to come in their mind clearly so that they can ask and receive the information that they need. These blessings we ask in your holy and precious name. Amen. All right, Sister Marche.
Thank you, Latron. Welcome, people. Welcome. Thank you all for coming out this morning. I know that your time is valuable, and we will be cognizant of that as we deliver the information this morning. Um, Again, my name is Marche Stevenson. I am an attorney here in North Carolina. I do not specialize in wills, even though I do wills. So I don't want that specialization to be put out there incorrectly. Um, I also have with me today, and I'm very, very privileged and very honored and very grateful to have with me our sister Tressa Proctor Hill to assist me with our presentation today. She's very knowledgeable about how not only the estate administration part of it here in North Carolina. So that's we're blessed to have her willing and able to help us out with that information today. We are going excuse me, the schedule for today is to start off with the wheels. Then we'll go into take a 5-minute break, go into state administration, and then with a question and answer session afterwards. Those who are uh, viewing us at home by via Facebook or other means, even by phone, then if you want to ask a question, please text it to this number here. The number is 704 923 7293. Again, that number is 704-923-7293. We'll go ahead and get started now. This is an overview of estate planning in North Carolina. And so I'm going to get my logistics here. I can't do two things at one time. I never was able to chew and walk at the same time. So, help, Megan. It disappeared on me. Okay. So what is estate planning? Estate planning is the process by which an individual or family arranges the transfer of assets in anticipation of death. I'm doing it right? Okay, Megan, I'm going to have to say next slide. I was trying to avoid that, but it's not working. The purpose of estate planning is it aims to preserve. I need the next slide, please. Okay. To preserve the maximum amount of wealth possible for the intended beneficiaries and to provide flexibility for the individual prior to his or her death. A good estate plan includes a will, trust, power of attorney, health care or medical directive, and beneficiary designation. A will can be, a will is your instructions about, doing it again, which way to go? We'll get this down pretty soon. Okay. She asked me to hold up, so I'm gonna hold up 1 second. It's okay. All right. So a will. Your instructions about what you want to be done with your money and property after your death. I want to take a pause here and think about some of the things I've heard dealing with different situations and people over time. But when you're looking at what you want done with your money and your property over time, you kind of like saying who's the best person to leave this to, because your sense of value in that property may not be the same value that that other person, the person you're leaving it to, has. So you want to make sure that you really consider who your people you're devising things to are, and whether or not they care as much about that as you do, because it may be bothersome or burdensome for them to receive that property. Does it cost them extra money to maintain it above what they have in their have access to? Is it taxable property, or do they not care at all and just going to sell it off and take the proceeds and run with it? So those are things to consider. One type of will is called a holographic will. It's a written will in the testator's handwriting, handwriting, and it's normally found amongst important papers that they have in their on their property or the house or residence once they pass away. There's no witnesses necessary to make that an official will. It's just take the proving of it when the estate is being administered will cause a little bit extra effort on, is this this person's handwriting? Is the forged document, that type of thing. That's a consideration of having a holographic will where it's in your own handwriting. A non-cupative will is an oral will. That's where a person when they feel like they're about ready to die. This is it. This is the last time I'm gonna see you. It could be, you've been on their sick bed for a while. Um, and it doesn't have to be the day that they die or right before they actually take their last breath, but it's that last illness where they tell you what they want done with their personal property. And it requires at least two witnesses, that the testator is telling them, I need you to listen to what I want done with my property. This is my oral will. They don't have to say those exact words, but they do have to indicate that they want you to be a witness to what they're saying about how to dispose of their property during their last illness. And the testator must die from that last sickness or injury. Okay. A self-proven will is what you go to the attorney for. And it's a written will that meets the requirements of the North Carolina General Statute, Chapter 31. It requires two witnesses and requires a notary. So that is acceptable will. You don't have to worry about it being challenged not accepted by the court as your last will and testament, because you've taken the steps to ensure that it's understood legally that it is your last will and testament. A trust. A trust is an arrangement whereby a person called a trustee holds property as its nominal owner for the good of one or more beneficiaries. What it ends up being is that you appoint someone to look after the interests of the beneficiaries over property that you are going to set aside for their benefit, either while you're still living or once you pass away. The purpose of a trust is to promote stewardship, preserve assets beyond one generation, avoid probate and taxation, protect your assets, and care for children with special needs. There are different types of trusts that provide for those purposes. There's the inter vivos trust, which is a grantor's trust established during the lifetime of the grantor. It's for his or her benefit, as well as some beneficiaries then living at the time. A testamentary trust is established upon the passing of the grantor. They set up some type of trust vehicle where their property or the assets goes into that vehicle and is then managed by the trustee for the specific purpose that grantor has set up. A special needs trust ensures that the care of a child for the care of a child with special needs for the remainder of their life. Hopefully, the trust will be set up to last that long, and the trustee is to ensure that they are provided for. A revocable trust empowers the grantor to terminate or revoke the trust partially or in its entirety. What that ends up looking like is the grantor has set up a trust for grandchildren to go to college. And let's say grandparent is young, therefore grandchildren are young. And by the time the last grandchild is out of college, that trust is ended because there's no one else to make use of the trust. We talk about wills, we talk about power of attorneys. Now, if you've been living long enough, you've seen where somebody needed somebody else to take care of their business for them because they were incapacitated and unable to do it for themselves. Now, that's a legal document in which the person who needs someone to look after their business, called a principal, appoints another person as their agent to make decisions and to transact and conduct transactions on their behalf. The two types of power attorneys are general power attorney. It gives the agent the same power as the principal in all area of the business and interest that that principal holds. That means they can buy and sell real estate in the principal's name. They can go into contracts in the principal's name. They can create debt in the principal's name. A special power attorney limits what the agent can do, and so by doing a power attorney, when you're doing your estate planning, you want to make sure it's a special power attorney and it limits what someone can do. So when you're trying to say, I'm giving John Jr. my house, you still own the house. Otherwise, they can sign all that stuff away if you give them a general power attorney. So to go along with that little warning, be aware that an agent has fiduciary duty to act in good faith on the principal's behalf. The principal remains responsible for the actions that the agent has, because when the agent is acting on the principal's behalf, there's a innocent third party that's there, that's acting, believing that person has that authority to do what he's doing, he or she is doing. So the principal makes sure that they are using the right person to be their agents. And a power attorney expires at the date by the date certain in the document or upon the death of the principal. So whoever your power attorney is for your business transaction to talk about to the hospital about what kind of resuscitation you have should you become incapacitated or ill, that person's power or authority ends when you pass away. Okay, some special notes here. Power attorneys can be filed with the Register of Deeds in the county courthouse. That really like ping aha moment for me, because I was not aware of that. But it makes a good sense, because once you file it, that means the court has endorsed it and it has a court stamp on it, and so it's legally binding on a third party to allow you to transact that business, even though again you still have some hardcore establishments that won't honor that, banks mostly, and maybe some other contracts that you may have to get into may not honor that power attorney. That's why the principal should complete the form that that institution or business has in order to avoid problems when the POA is presented for execution. And this is especially important when the principal becomes incapacitated or incompetent, because at that point, they don't have enough, I say, competency to even to choose someone to act on their behalf, not legally. Trying to get my slides to go. Okay, a living will is it's a healthcare or medical directive that a principal will establish. This tells whether or not they want to be resuscitated, should they get on ventilating machine, or have to have life-sustaining assistance at a hospital in that type of environment. So it's called a living will or doable power attorney, and it's written statement detailing a person's desire regarding their medical treatment in circumstances in which they are no longer able to express informed consent, especially an advance directive. It designates who will make the life-sustaining decisions on the person's behalf should they become incapacitated. Now, again, once the person passes away, that power attorney, that doable will, is no longer valid. Other terms to know: decedent, the person who dies. It's also the same person as the testator, the person who makes out the will. The administrative CTA. When a person makes a will, they designate who their executive is going to be, who they want to make sure that whoever they're giving whatever to gets whatever they're giving to them. I can't say that twice fast. It's really a tongue twister. But it's administrator cum textments annex. Means administrator to the will is annex. So when the people who are named, normally it's 3, maybe 4 people named in the will as being successors to successor executors, if they don't qualify for some reason, or if they decide they don't want that responsibility, then they can decline it to serve that manner. If everybody does that, nobody qualifies, or people pass, that you haven't renewed your will frequent enough, and all those executives have passed on, the court will appoint the administrative CTA to perform those duties on your behalf. The executor, of course, is the person appointed by the testator to his or her estate to administrate his or her estate. Testate. The person is when the decedent leaves a will. I'm sorry, I didn't change that slide. Okay. Intestate is a description of the state where the person dies without leaving a will. Heir. A person legally entitled to the property of the decedent on his or her death. Beneficiary. A person who derives advantage from something owned by the decedent, especially a trust, will, bank account, or life insurance policy. And again, that's where some of these items pass outside of the will, but you need to be aware that you need to cover those items as well, since it's part of your estate. Excuse me, not estate, but part of your assets. Next of kin is the person closest living relative or relatives. It may be of equal level, like having 2 sisters, 2 brothers, a niece and a nephew, a sister and a niece, those type of things. Real property is fixed property, principally land and buildings. Excuse me a second. A mobile home is not real property unless it's properly affixed to the land according to whatever the state laws is for it becoming real property. Personal property is movable property, such as a mobile home, who's not properly affixed to the land, and belongings exclusive of land and buildings, such as jewelry, cars, ideas, poetry that you've written, paintings, furniture. Those things are personal property. Pers stirpes. Let me slow down a minute here for pers stirpes. Pers stirpes deals with order of inheritance. When a person in North Carolina dies without a will, they have, let's say, John Doe dies without a will. He has a wife. Normally you say Jane, but Mary keeps popping up in my mouth. Mary Doe is his wife, and they have 2 children. And he also had a child from a previous relationship. So there's 3 children and a wife that survived his death. John Joe Jr. has 4 children. Sissy Doe has 2 children. And his child from a different relationship, let's call him Hank, has a child. Sissy died 2 years before John died. So when John dies yesterday, anything that he owns is a possibility that the survivors all will share in that those assets. In some jurisdictions, and I think North Carolina is also one of those jurisdictions where the parents have a child that's not that belong to both parents, then the estate is divided between the surviving spouse, and the child who is not part of their whole relationship. So that means that when the estate is distributed, wife is entitled to 50% of John's estate because she still owns 50% of the community property. And so she owns 50% of the 50% that John has. And then the 50% of the 50% that John has then goes to the children of Hank. No, he's still living, so it goes to Hank. Doesn't go down the ladder because there's still people at the right level at that point. So Persepolis, be aware of that. Just because someone is passing, that their heirs is entitled to what they would have gotten had they still been alive. Okay, that's the peculiar thing about Persepolis. Okay. Holding for questions, so that's why I'm kind of going through this kind of fast. I apologize to you if it's too fast, but you can always tell me to slow down. Right of survivorship. Right of survivorship speaks about jointly owned property. Now, remembering that North Carolina law, North Carolina is not a state where there's common law marriage. Now, South Carolina is a state where there's common law marriage. And North Carolina normally honors common law marriage that started in a different state, but it doesn't appear, and you can help me with this, to be true where it comes to estates. Okay, so I'm correcting that statement. So just being, so when two people who have established common law marriage somewhere else, or two people who are unmarried living together and they have property that's jointly that's owned jointly in their individual names. If the contract or the deed for that property says with right of survivorship, the person who is not the spouse of the other person who survives, let's say Harry Morgan, for a different name because I like names for some reason, and Susan Daniels are cohabitating in North Carolina and have not established, it doesn't matter if they establish common law marriage in South Carolina, but they're cohabitating in North Carolina. They own property in North Carolina jointly. Harry dies, then Miss Daniels would be entitled to the house that Harry owned with her, and she can retitle it solely in her name. Okay, that's that. And businesses act the same way. If you own a business jointly with someone else, a partnership, a corporation works differently. A partnership, then right of survivorship. Whoever survives the person who dies first is entitled, with the right verbiage in their contract, to receive full ownership of that business if once the other partner deceases. Okay. Life tenancy. Normally, this is when a person has family land, and I know a lot of people in this area have family land that they may be living on, and the spouse, of course, is not in that bloodline. The spouse could be given a life tendency to live in that home for the remainder of their life after the bloodline spouse dies. So that's something, again, to be aware of happening here. So who should make a will? A person over the age of 18 who is competent, meaning of a sound mind, knows what they own, knows that they are making a will or establishing a trust, and they are not under duress or threat of harm by someone else. Beneficiaries, I got my Eastern Southern accent going on here, are paid directly when titling is done properly. So life insurance beneficiaries, make sure you have someone's name on that, because if you use what we used when I first went in the military as by law, that by law means that those proceeds go into your estate. And then it's distributed to your heirs. When you name a specific person to receive the proceeds from your insurance policy, and your intent is that they bury you first and take the remainder, make sure that that's what they're going to do. Hopefully you will choose somebody who's responsible, because some people aren't. And when they see those dollar signs, they say, oh, I'll pay my portion. You guys come up with the rest. So something to consider who you choose to do what you want done. Bank accounts, you can put that beneficiary name. I wouldn't do it so much as an owner, because that means that they have rights while you're still living to go and clean out that account, leave you $1, and go on about their business. A 401k or 403b. Any annuities that you have, IRA accounts, joint with right of survivorship on accounts, payable on death, transferable on death accounts, joint with right of survivorship tenants by entirety of real property, and joint with right of survivorship title automobiles. Those things do not go as part of the probate process for your estate. Review each time you become aware of a need for a change your beneficiary designations. People fall in and out of favor with each other. Do you want that person you're mad at to keep right to your money? You got to make that decision. Someone stops speaking to you because you offended them. Do you want them to receive your money? Make that decision. Otherwise, at least every 3 or 4 years, to make sure that the person is still living, is still interested, or whatever, you still want them to have it. There may be someone else that usurps that position with you, a favor with you, and you might say, okay, that Janie Sue is now 35 years old. She has a job making more money than I'm making. This is not going to impact her and benefit her the way it will Joan. So you make that decision at that point. Okay. Know your coverage. Life insurance companies will usually reduce coverage for people over the age of 60. So a term life plan amount through your employer may be less than the original face value when you first started working there. Need to also look at, is there other insurance you might want to consider getting, because of the fact that you're older now, and you want to make sure that you have some burial, I'm quoting that, coverage for you if you don't have other ways of getting buried in or even cremated. Should you however you choose to for your remains to be disposed of. Veteran compensation benefits. Um, they would not, those benefits will not continue after the death of the veteran. A spouse or dependent children must apply for dependent indemnity compensation to receive further benefits, but only if the veteran dies from a service-connected disability. So if you're a veteran and you have your service-connected disability and it's for your knee, your ankle, your hand, normally those aren't things you're going to die from. But something you can die from: high blood pressure, high cholesterol, um, gastrointestinal disorder, GERD, those type of things you can die for. If you have that too, and you could have it connected to your service, please do so, even though you might be 100% for PTSD. They say people die from PTSD because they could commit suicide. But other than that, the likelihood of you dying from PTSD, unless you're in one of your rage modes and you call and you have an accident, the likelihood is going to be slim to none. So something that could cause your death, if you're a service-connected person, please have it service-connected so in case you die, and that's one of the contributing factors, your family can be taken care of monetarily going forward. But be aware that the amount of the dependent indemnity compensation may not be as much as the veteran was receiving when he was alive. Retirement and pensions plans. Certain plans do not continue beyond the life of the owner's spouse. Some government plans offer survivor benefit plans at a small percentage of the amount the owner's spouse's entitlement. It ensures that the non-owner spouse receives the benefit, usually in a reduced amount, for the rest of their life, unless there is a provision about remarriage. I skipped a slide. Don't mind. Okay, other advice. Review your will, POA, and other state documents as you become aware of the need for change, or at least every 3 to 5 years. Maintain a list of your creditors who can make a claim against your estate. People come out of the woodwork when somebody dies, so you want to make sure that your family is informed that whether or not you have that debt or not. Because some of us don't keep those paperwork for a long period of time. Maintain a list of debtors who your estate can make a claim against. If you make a loan to your best friend and he owes you $10,000, you need to have a record of that so that they can be collected and used in your estate. Purge. I put that big. At an old age, like some of us are, we tend not to clean up as much as we used to. And we can't tend to hold on to stuff. This might be good for this might be good for that. But as my husband tells me, make sure he's not in the audience. As my husband tells me, Mache, if you don't go in there and move that junk out of the house, when you die, I'm just throwing it all in the trash. Well, I think I got some treasures in that junk. He ain't gonna take the time to go through it. And a lot of other people don't want to take the time, and it's burdensome when you're grieving to have to take the time to go through it and find this and find that and move this out and get rid of this and that type of thing. And I know people gonna be coming there asking for this, asking for that, but that's all they're doing is asking for one piece. They're not asking, to go through everything and help purge or get rid of stuff when you're gone. So owe it to yourself, one thing, so you'll know where things are and what you got. You owe it to your family to get rid of stuff that has no value and that you're no longer using. I'm still working on myself, so nothing else needs to be said about that. It's called self-incrimination at this point. Okay, burial. Where possible, include pre-burial plans in your estate plan. It provides the grieving heirs with some relief when making a final plan for you. This also will tell them what you want done with your body. Do you want to be buried? Do you want to be cremated? Where you want to be buried at? Where you want to be cremated at, and stored at. It tells them sometimes, people trying to put a program together, they don't know what your favorite song was or what your favorite scripture was. Share, if you make up this is what I want, a little piece of paper and put it close to your will, it'll be something that's easily found and people can honor you the way you want to be honored, as well as it relieves them from having to make that particular decision about it. And VA cemetery administration benefits are available to veterans and their spouses who qualify. And this may reduce the cost of your burial if you're a veteran. And you don't have to be a compensated veteran. You don't have to be receiving benefits. You just need to be a veteran. So, and your spouse can be buried either below you if she dies first, or above you if she dies second. So that again, that's reducing the cost of the burial. Okay. Yeah. Well, I'm talking. I guess I'm saying this because of the fact that I'm talking about a Veterans Administration cemetery. And I lost a slide, I think. Yeah, I did. So your estate plan is complete. What now? Or now what? Don't make it a treasure hunt. Okay? Put your documents in a safe and secure place, like the estates administration section, another eye opener for me, of the county courthouse. A safe or safety deposit box, and tell somebody where to find it. And usually it'll be your executive or your heirs. Okay, now the testator has died. The POA ends and the will begins. At this point, let's take a 5-minute break and then we'll come back and do will administration.
And for those of you that walked in, if you have not signed for those of you that have not signed the sign-up sheet in the back, we do have a sign-up sheet on the podium in the back. If you can fill that out, that would be great. That way we can keep you informed about other sessions that we have in the future. Thank you.
Are we ready to begin? All right, good morning. Thank you all for coming out to share these sessions with us. My name is Tressa Proctor Hood. I am a clerk in Mecklenburg County Courthouse Estates. I have over 15 years in court administration, and I am into my 5th year of administration working in estates. Didn't Ms. Marche do a great job? All right, what I'm here to give you is a bird's eye view of what happens when one does not have a will. It's called estate administration. When you will come to my department in your clerk's office, the courthouse. You will come in to the estate department, come to my office. I know exactly what you're there for because everyone that comes to estates have experienced a loss. First thing I'll ask you, who passed away? Some say my mother, my father, sister, brother, uncle, auntie. I will first ask them, did they have a will? Most of the time, the answer is no. I will now tell you the importance of having a will. There is so much involved emotions that take place when there is no will. Family getting into with each other. Grandma wanted me to have this. Uncle told me I should have this car. The money in the bank account, what do we do with that money? There's no will. How do we disperse that, distribute that, divide that amongst family members? That's what I do in my department. Again, my name is Tressa Proctor Hood, and I am not an attorney. I'm here to give you some advice, instructions as to what to do without a will. And I will attempt to work this here. Okay, put it that way. What is an estate? The assets and liabilities left by the decedent at the time of his or her death. And again, there's no will. So you're wondering, how do we take care of everything now? Probate. The estate administration process consists of 3 general stages: marshaling the decedent's estate, paying creditors, and addressing tax matters of the decedent's estate, and distributing the remaining assets of the beneficiaries to the beneficiaries of the decedent's estate. Okay, let's pause for a moment. You spoke of creditors. There's still bills that need to be paid. How am I supposed to pay these bills? They're still coming in. There were balances left at the time of death. How do we pay these? These are questions that we will answer at the end. Who can qualify to probate a will? Where is the probate filed? All right, let's talk about that. Who can qualify to probate a will? As long as you are over the age of 18, any family member, an heir, cousin, sister, brother, it just cannot be a convicted felon. They must live in the state of North Carolina or in the county in which you were a resident. If not, you will have to file a resident process agent, and we will file as a resident process agent, and we'll talk about that as we go on. Where is probate filed? Probate is usually filed in the county in which that person was a resident. So if you live in Gaston County, if they lived in Gaston County, don't go to Mecklenburg County, try to file a will or start probate. Now, I'll also give you an example of someone passing away in Texas. They were there just visiting. They were a resident of Mecklenburg County, Gaston County. They decide to bury the body and last remains in Texas. They drove to Texas in their vehicle and they died there. The family decided to bury them there. Now that the funeral is over, the burial has taken place. Now we want to know, what are we going to do with the car? How many of you think that we could register the car in Texas? How many of you think that we can start probate in Texas? No, ma'am, no, sir. Even though that car is in Texas, has North Carolina plates on it, you have someone interested in purchasing the vehicle in Texas, you'll still have to go through North Carolina. Okay, there are two types of estates. There's a small estate that's with assets under $20,000. And there's a full estate that's assets greater than $20,000. Small estate. Assets do not go through probate, even if there is a will. No creditor notice required. Cannot be opened until 30 days after death. There's no application of personal representative required, and it must close within 90 days after opened. A paid in full funeral bill must be presented. Now, the person that opens the small estate, can we enlarge this a little bit, Megan? Thank you. The person that opens a small estate, it could be a family member, it could be a creditor, someone that paid the funeral bill, that's what I mean by creditor, and wants to be repaid. They learned that a small estate was open and there's money there. A small estate consists of a vehicle, it may be a bank account, as long as it's totaling under $20,000. It can be open anytime. 3 or 4 years down the road, oh, you realize we still have this vehicle. What are we going to do with it? It's still over in grandma's yard. We can actually open a small estate and put that vehicle on that because it's under $20,000. We ask that you present a paid in full funeral bill because we like to make sure that the funeral services have been already paid. And if someone in the family actually paid the funeral bill, they can actually be repaid through this small estate. Any questions? Okay, we'll keep going. Opening a small estate requires $120. And we ask that you pay that at the time of filing. So why would you open a small estate? As I stated earlier, there's a vehicle under $20,000. There's assets in the bank account that you can list under the small estate. It has to be opened 30 days after death. Cannot be before then. You must be a North Carolina resident in order to open that estate. Full estate. There are two types of full estates. Intestate, Marche spoke of that. Testate. Testate is with a will. Intestate without a will. must be $20,000 and over. We always let them know, opening a full estate, meaning assets over $20,000, but that means you'll have to place a notice to creditors in the newspaper. All of the creditors must be notified within a timely length that they have to file a claim against the estate if they expect to be repaid. That's like a Lowe's bill that grandma had, Sears bill. I know Sears is no longer around, but Sears, any outstanding bill or creditor that would like to be repaid, it can come in under a full estate. And this is just the application for full estate. You do not need to wait 30 days after death. It can be filed immediately. A lot of times these full estates stay open for years, depending on the amount of the assets that are involved. In a full estate, that will be, you can also list a home. If you're planning on selling the home within a certain amount of time, and we say you can list it if you're planning on selling the home within 2 years of death. You can enter the proceeds into the full estate in order to be distributed to the heirs. Test date again is with the will. You come to the courthouse. I ask, did they have a will? Yes. Are you wanting to open a full estate? Yes. Are the assets over $20,000? Yes. Are you wanting to probate the will? Probate the will meaning to enforce the will. Non-probated, just to put the will on file. I want to pause here and speak about wills just a little bit. Marche spoke on it. If you have a will already written, you can also put it on safekeeping in your local court. It's just a place for them to keep up with it, so you don't have to go through papers after papers, or your loved ones wouldn't have to go through papers after paper at home just to try to locate the will. We know you tell someone that it's at the local courthouse. Anything happened to me, my will is on safekeeping there. It's only safekeeping. No one can actually come and touch that will until you are deceased. So that's the difference between putting it on safekeep and filing it. It's filed at your death. Go ahead.
So if you go and say like a person's grandparents go and do the will because their child has died and pass everything down to the grandchild, whose responsibility is it to put it on file at the courthouse? Like, is it the lawyer or the family? Because that person's will ended up missing because another family member took it. Okay, so will. So.
Hold your questions to the end. Don't forget. We're going to go ahead and move on. So,
Check 1, 2.
as I stated, this is just a bird's eye view. Any additional questions that you may have that we're unable to answer, seek your local clerk's office. We're going to go on to year's allowance. This is a very important topic that I wanted to share with you. A year's allowance is a special provision given to a North Carolina resident that spouse passed away. It's a special provision given to North Carolina residents of a deceased spouse. It must be filed within 1 year of death. It is protected, $60,000 in assets protected against creditors. Now, this is not, you're not given $60,000 to use to your benefit. What this is just like a credit. In the event that a check comes to the estate estate of John Doe. 20 years after he passed away, I didn't know he had any Duke Energy stock. This is good for the lifetime of the spouse. Bring it to the courthouse, and we will be able to give you something to take to the bank to cash the check. Whatever the amount of the check is, say the check is $5,000, we subtract it from the $60,000. You still have $55,000 to use for the remaining of your lifetime. It's a provision given to you, and most people do not know about it. So if you have a family member that had a spouse to pass away within the last year, that's the thing, it has to be filed within 1 year of death. Ask them to go to the courthouse and get information about, it's called a widow's allowance, year's allowance. It's a special provision given to them that they can take advantage of. Am I going backwards? Okay. Okay, let's talk about transfer of titles. A deceased person's name cannot be on a title. Remember earlier I spoke about there was a vehicle that's in grandmother's yard that grandpa used to own. It's no longer working. She wanted to get it out of her yard. She go down to the DMV with the title and the death certificate. I have somebody that's interested in purchasing the vehicle. I just want to go ahead and get the title transferred over. If she has not gone to the courthouse to take care of the vehicle, get the title changed from grandpa's name into her name, there's going to be some difficulties there. She will not be able to do it. DMV will send her back to the courthouse to take care of that. Transfer of titles, we get that all the time. Someone come to the courthouse. I have someone that wants to buy my husband's car. I went to DMV. They sent me back to you guys. First thing I asked them, well, ma'am, did you come to the courthouse when he first passed away? No. Well, now he's been dead over a year, so we cannot do the year's allowance now. That was the form we spoke to previously. So now we have to look at other options, and the transfer of title will be the option. And that is a DMV form that we have at the clerk's office. It's called the MVR 317, transfer of title. Family history affidavit. A family history affidavit is a form that is used in every estate. What the breakdown of this form is, you have to list everyone in the family tree. It'll ask for questions like, was he married? Was the deceased married at the time of death? Did he have any children? Were any children born outside of the marriage? Did any children predecease him? Or questions like that. It'll ask all of that. It'll ask about their family members, brothers, sisters, dead or alive, the one that are deceased. Did they have any children? Because actually they may be entitled to some of the proceeds from the estate. So a lot of people try to go around this family history affidavit, don't list everyone that's in the family, thinking, they'll get their proceed. But you are sworn. This is a sworn document, and you can be held in contempt of court if you are found in default. Bond requirements. The purpose of a bond is to protect the heirs of the estate. Depending on the circumstances, a bond may be waived. The estate administration section of the county where the estate is probated will decide when a bond is needed. And usually a bond is needed if you are out of state and the estate is being open in another state. For instance, for example, if we're opening up an estate in North Carolina and the person that qualifies to be over the estate lives in Georgia, a bond may be necessary. Please note, the clerk of the Superior Court in all 100 counties in North Carolina serves as the judge of probate and cannot practice law or give legal advice. So that is why you should have a will. An attorney will prepare a will for you. When you come to the clerk's office, which is my office, we don't give legal advice. We'll give you information, but we always say if you want legal advice, you'll need to hire an attorney. We'll give you the resources. We may give you a list of attorneys. In this case, it'll be probate attorneys, estate attorneys that you can use to direct your questions or your concerns, or you have your will drawn up. And I will input this: if you are a member of State Employee Credit Union, they will prepare your will for a discounted price. If you need advice, you should consult an attorney, especially regarding disbursements of any funds, any questions about handling insolvent estates, or concerning federal and state taxes payable to the estate. And I will also say, whenever you file a full estate that's assets over $20,000, you are going to file taxes on behalf of the deceased. You must keep accurate records and file accurate accounts. Court costs and fees must be paid to the clerk of the Superior Court. You will be informed about the amounts by the clerk's office. Each estate, there's a filing fee. Filing fee is $120 for a small estate, $120 for a full estate. You will pay a percentage of the assets in the full as well as the small estate. And the assets is a percentage, and it's 0.004 times the balance that's in the estate.
Okay, we're gonna share this mic. Okay, again, before we take questions, I want to distribute or re-announce the phone number to text your questions to 704-923-7293. Now, if you have a question, please raise your hand and we'll get a mic to you so that the people viewing at home can hear what your question is.
I'll make it shorter. My question was, when you know there's been a will filed, whose responsibility is it to file it at the courthouse? Because a situation in my family, I was the heir. I was there when they did the will, then the will went missing, and it was never filed at the courthouse. So is it the family or the lawyer?
Well, I, as an attorney, when I do wills, I hand 2 copies to my client and tell them they're responsible for the safekeeping of that will. Filing it's not called filing. Taking it to the court to be safeguarded is a decision that that person, the testator, can make. If the will gets missing, your options are, if you are the sole heir, your options are to, obviously, if the will is missing, there's no record of who the executor is. So if someone's taking possession or custody of the assets of the estate, then you as an heir, possible heir, can raise that issue with the clerk's office and possibly file a legal action against that person to get it all sorted out.
Okay.
Yes, Megan. You need a mic. You need a mic.
Sorry. And I just wanted to piggyback off of what Ms. Marche was saying. The copies will be given to the person that the will is done for. But remember that that document, life does not get breathed into that document until it's filed with the estates department. So we're not going to hold on to that. That's going to be for you all to handle. So once it's gone out of the office, it's out of our hands at that point.
Because it's not, when the testator is still alive, it can't be filed. It can be safeguarded at the courthouse. It's an option. It's an option that they choose for safekeeping their will, to safeguard it at the courthouse, or in their safe, or in a safety deposit box. Okay. Wait for the mic, please.
In the meantime, there is no fee to safeguard the will. Just bring it to the courthouse and we'll give you a copy of it being on safeguard.
They were pretty old, and I was there, but that was many years ago. So I don't know if the lawyer made that clear to them. But what ended up happening is we went into probate, and then everything worked out.
Okay. And speaking from the attorney's point of view, attorneys used to keep a copy of the executed will in their office, but a lot of them die. Their practices close out, and that document is sitting somewhere, that can't be recovered, or nobody knows how to recover it. So for me, as old as I am, when I make a will, I don't want to be responsible for safeguarding your will. Sorry. If that's something you want, you have to go find somewhere else to get it done. Yes.
Question. When you said the family affidavit form, say for instance, you got blended families. I'm just going to use myself. Say for instance, I passed away. Keith lived. Neither one of us had a will. Now Keith dies, and now his kids will come and fill out the affidavit form. What happens to if my child is still living?
Well, when you die, unless it's a concurrent death, there's time for Keith to fill out that family affidavit at that point, because they're answering in regards to his marriage and your life. Okay.
So it would pick up my child.
That would pick up your child.
Okay, but if he doesn't get a will, what happens?
We're not talking about a will. We're talking about intestacy.
But it still would have to go through the probate.
Yeah, and it still has to show that you had a child that was not Keith's child. Okay, and anything, and since more likely than not, since Keith will be will be entitled to 50% of the community property, and then your child or children will divide the other part
After I pass.
after you pass. That's
Okay.
before he passes.
Gotcha. Okay.
Okay.
All right.
Good questions.
I have
Go ahead, D.
my question is, y'all mentioned the 20,000 and the situation with the car being in Texas. Okay, say for instance that car is 10,000, but you got other monies that could add up to 12,000. So I'm not understanding the 20,000 when you got other monies.
The $12,000 value of the car, was $10,000 the value of the car, plus the $12,000 cash value from other,
Something,
from something, that takes that estate over $20,000.
okay. So it has to,
It has,
stay
that's
at
a
that
full,
20.
that becomes a full estate.
Everything has to be under 20,000.
Not everything, excuse me. Everything has to be under 20,000 or everything, or it will be over 20,000. Everything doesn't go through the estate. I want to make sure, look at her, because there, anything that has a beneficiary name on it, it doesn't go through the estate. So that doesn't increase the value of that estate. It's things that go through the estate, where, again, where the house is involved. If it's not titled with someone else's name, you're gonna have to answer the rest of that.
As far as the
House.
the house. So if there's a house, real estate does not go through probate at all. So unless you're planning on selling the house within 2 years, then you plan on selling the house, and those assets from the sale of the house will go into a full estate, because I'm sure it's going to be over $20,000.
And again, that gets back to the titling of the real estate. And while we pass the mic, I want to thank Megan for her assistance this morning. I would have been lost if she didn't show up and help take care of me. And thank you, Brother Man, for carrying the mics around. And you and you too, Pastor. Go
Okay,
ahead.
So my dad and I went and took care of business like that this week, but the lawyer
Could you
only
put
gave
it
us,
more like this?
he only gave us one copy. He did his will, healthcare power of attorney and power of attorney. So my question was, I thought he should have kept a copy, but you answered that question just now. But with only having one copy, if I made a copy, is that okay? Just to have,
It's still not. That's okay for you to know, in order to know what's in the will,
okay.
but it's not
not legal and
not a legal
without
copy.
the
I mean, not a
witnesses and the
legal
notary.
document, because it's not the original.
Okay. Second question.
Again, the
the-
mic, please.
Oh, I'm sorry. Second question. So I'm on his account at the bank, but I'm not sure that I am his beneficiary. So as far as like the power of attorney, do they need copy of that? Or like if I have to start handling his business?
Most banks have their own documents that they want you to use to be the power of attorney.
Okay. So
Okay.
we are a part of the state employees credit union, so they can take care of that.
No. Unless you're talking about a bank account at the state employees union, we're talking about a power attorney.
Okay.
Okay, if the account is at Bank of America, you got to fill out their form.
Okay.
State employees credit union, more likely than not, has their own form they want you to complete for the power of attorney. But that doesn't mean that you're entitled to the funds in that account. Okay, power attorney just means you can transact his business. It doesn't mean that you're entitled, once he passes away, to the funds in the account. It may have to go through probate if you're not named as the beneficiary.
So he needs to designate me as the beneficiary of
Yes.
the account.
Yes. I need a mic. But she just said once he passes, POA ends, as we said earlier.
And along with the will being on file at the clerk's office, it says it's not on file until you're deceased. It's at the safekeeping. So if your father was to pass away and the will was at safekeeping at the courthouse, once he passed, bring the death certificate. Let us know the will is already in safekeeping. We will pull it, and then we will go ahead and file it.
Talk, if you don't mind, we'll get the questions, 1 second. Talk, if you don't mind, about who can see that will while it's on safekeeping.
Only the person that the will belongs to can view that will. They can pull it, they can withdraw it, they can make a new will, taken totally out of safekeeping, but they are the only ones that has access to that will. So when they bring the will to our office and say, hey, I want to put my will in safekeeping, we will have them fill out a sheet. We get their identification and all of that and give them a copy that the will is in safekeeping. And hopefully, we always tell them, make sure you let a family member know where your will is in the event of your passing. So they're the only ones that have access to that will.
Minister Connor.
I just wanted to say one thing that I've just learned. I closed out my sister's
Estate.
estate on this past Thursday. And one thing that I've learned is that when you have an account, like me and my sister had an account. Well, she had her own account. And then when they called hospice in, I spoke to her social worker. And she says, if something happens to your sister and she can't speak or go to the bank, you need something. So she gave me this form, told me to call the bank, and the bank gave me a form. It was a joint account. And he was saying, you have to make sure it says joint, because if you have power of attorney, and I had power of attorney while she lived, but once she passed, and I took that, well, that form was already in place with the bank. So when I went to the bank and I took the death certificate, I still was allowed to use her account to pay her bills because she still had a house payment. She still had, bills that need to be paid until we could settle up. So I think that's very important because a lot of people don't know. I didn't even know, because had not that lady called me, I would have been trying to pay her bills, because I couldn't take anything out of that account once she died. Because every time I would go to somebody, it would say, what's the date of death? Because after that date of death, it depends on what kind of paperwork or filing you have in place. So I was able to keep paying her house payment until we decided we had to sell it. So, and to keep the power on so that somebody could come in and sell the house, we still had to have that in place, because they will tell you, if you're not on there, then we need to know how. When I filed the papers at the probate, then I became the administrator. And so I was able to talk to people, but a lot of times they won't talk to you. But the bank, you need to make sure if there's an account with that person's name and they don't have, okay, she had a life insurance, but it wasn't enough to pay the insurance, wasn't enough to pay for the burial. So had I not had that account and able to go in that account and pay the difference between her life insurance policy and what the funeral home was, then I would have been left, because you still can, once you become the administrator, you can do things, but it's a process to me, but it's just good to be prepared. I've just learned that.
I also want to add something, and I know in our electronic days, a lot of us receive our statements online. What I found very helpful is continue to get paper statements, because when you pass away and you do not have a will and you have to go to the clerk's office, we ask, do you know what was in the bank account? No, I can't. He got the statements online. I don't know. So when you're doing estate administration, the only thing you know is, I don't know. So we'll have to put on that line to be determined. We don't know what was in the bank. I just know he had a Bank of America account, but the statements came online. And as soon as they get wind of your death, the accounts are frozen. You're not able to get any information. But if you're still getting those statements, or if you still have that last statement that came in the mail to the house, it helps you a lot with the administration of the estate.
One more caveat before what we're talking about, normal things and access to stuff. If you have a safe deposit box and your will is in your safe deposit box and other valuables, you need to have a co-owner to that safe deposit box. Otherwise, it's going to have to go through the court system for you to get in there to find the will. Other thing, next thing is, yeah, you have access to go in and inventory the stuff in the safe deposit box, but you cannot remove anything until the probate is finished. Go ahead, Pastor.
Yeah, this is I just want to say hello, everybody, and I got to get to my next appointment in just a little bit. But I want you to know this is very valuable information because oftentimes as pastor, I see the results of this when it's not done. So I'm glad that everybody's here. I'm glad that everybody is watching and those that'll be watching in the future. I do want to make mention once again the stressing of the power of attorney. Once the person dies, you can go ahead and take that down to the funeral home and leave it there because it's no more good. You got to have that will, and somebody's got to be a minister of that will. You need to know where it is. Thank you for bringing out that point about online banking, because if you do have online banking and it's coming to their email, do you have their email address? Do you have their password? So if you don't have the password, if you don't have the email address, you can't pick up a lot of valuable information about the online bills that have been paid. It's not a paper trail coming there to the house. It's online. You have to make sure that you can, somebody can get access to all of this stuff. And make sure, once again, that you have a will. It'd be better to have what they call a ma and pa will. If I die, she get everything. If she die, I get everything. Rather than trying to, well, we got to figure it out because, you know, she got her kids, he got his kids, and they're adults or whatever. It's better to go ahead and have it laid out first and then come back and put it together much better. So I want to point those things out. Also, not trying to give a commercial, but it is worth saying, State Farm now has an insurance policy where you can go in today, $15,000 insurance policy when you walk out the door. Too many people are passing away and nobody got no insurance. And the average funeral, if you do a cremation, is going to be about $1,500. And if you're going to do a full funeral, don't forget the opening and closing of the grave, you're talking about $15,000, depending on whether you do it on a Saturday or a Sunday or through the week or after 2 p.m. through the week. Opening and closing of the grave can be as much as $3,000. So you got to make sure that you got all that squared away. If you're a member of a church that has a cemetery, you don't have to pay for the plot, but you still got to pay somebody for the opening and closing of that grave. And depending on what time it is what they're going to charge. And if it's Sunday, of course, it's double time. So you got all these things that you want to make sure that you're taking a look at. Wanted to point that out.
Minister Don, do we have any questions? Okay. LaShawn?
Yes. For first, we have a question on the floor regarding the office location. So if you can give your office, I guess, Ms. Hood, or your office location.
I work in Mecklenburg County Court, and that's 832 East 4th Street here in Mecklenburg County, Charlotte, North Carolina. There is an estate department located here in Gaston County Courthouse. The clerk of court is Leanne Rankins. She heads that department. So if I can assist anyone, Mecklenburg County, our forms are pretty much the same across the state of North Carolina. The process and the procedure may be a little bit different, but it all has the same results. So if I can be any assistance, if you see me, if you have questions that I can answer, again, I am not an attorney. I can give you to go-to persons, go where you can find your information, help you with getting those forms, but I am not able to give legal advice.
Thank you. So my question is, so I don't know a lot about probate, and all this stuff. I haven't had the, I guess I don't want to say privilege of going through all that. But here's the thing. So I've always heard that probate is like not good. You don't want your stuff to go through probate. But is there a way to, if you have a will, if you have a trust, or can you avoid probate? Or does some things have to go through probate? How does that work?
If you have a will, the only reason you would visit our office is to file your will and to have the will probated. Probated meaning to put it into force along with your death certificate. To avoid probate is to have a will. Now, some things in the will, I'm sorry.
To avoid probate, you want to have a trust or beneficiary. But everything else that's not a trust or beneficiary is going to be looked at by the court, whether you have a small estate or a full estate. The court is going to be involved, and you have to account for everything that's in each of those estates.
So if you have your will and you have it safeguarded, you have your trust, and all that's complete, you should be good. You have all your beneficiaries listed, you know, we should be good.
You should be
Theoretically.
fine. Theoretically. I mean, everything's not how you say law, you know.
Right.
But that's the best advice.
They need to know where it is, who's got it. Right. That part is important. It stays to the bottom of the third drawer. Right.
Okay. Right. Okay.
Also on beneficiaries, I'm gonna be real quick on this. And I try to update my beneficiaries as I get new grandchildren. And they seem like they just keep coming every time, every other year, I'm adding another beneficiary. So keep that in mind also. You don't want at your death or your passing one child left out because grandma and granddad, they forgot. They didn't, consider updating the beneficiaries. So that's something people tend to kind of overlook and forget about also.
I had a question. What do you do if, when you married, your husband have kids from a previous marriage?
I can't hear your question.
Okay. What would you do in the situation if you have a child and your husband has
Could you put your
kids?
mic up closer?
Can you hear me now?
Yes.
Okay. You have a child, your husband have children from a previous marriage. And if you didn't have a will and you both will be in an accident and killed at the same time, what would your children would have to do, or what would they go through in order to take care of what needs to be done as far as, like you say, estate and stuff like that?
We talking about the instance where people die within a day of each other. They have the accident. If they both die instantaneously, there's neither one survived the other. The court has to decide who the survivor would be. If one dies at the scene and then one is recovering, then that person, and let's say they maybe live another month after the accident, that person survived the first person. So by the time we get to that second person dying because of the same accident, you've already got the estate separated about let's say the wife passed at the scene, husband didn't. The wife's estate comes up. So whatever should be dealt with as far as her heirs, okay, her lineage, her children. So he would get 50% of what she owned in other community property, and the children will share the other 50% of the community property that she owned at the time of her death. And then when he dies, let's say a month later, then it's his children, his heirs, that has to take a look at what's remaining at that point in the community property, and which is now moved into his estate. So that's how it goes. It's kind of, the court will have to make that decision. Go ahead.
Yeah.
Again, the court will have to make that decision about whose estate. I don't, who survived whom. Somebody has to have survived the other. That's a question that the court answers. the probate court answers who survived whom. If there's no survivor, the court will still have to answer that question.
And it may come down to the time of death. Something just so simple,
It does come
come down
down.
to the
Okay.
time of death.
Okay, okay, I see what you're saying. And Priyanka, I also have, another, I don't know if it's a question or what, but, when you was talking about paper trail and, your,
Thanks.
bank statements and stuff online. I ordered a book, my last will, and it has everything in it for all of your stuff that like your will, if you have any money and stuff that's left, for your kids. It has area and stuff for passwords and stuff and everything. I ordered that book and I put everything in it that I needed to put in it. Where the will is, where's everything at, and I put it in a safekeeping. So I have it to the point to where I have certain ones know where everything is at if something would happen. I was just throwing it out. Maybe somebody can look up something that they can have everything broke down on what they need.
That's good.
So
That's
I'm
good.
just throwing it out.
Okay, I'm just doing handouts now.
Any other questions on the floor?
They have something else to talk about.
Okay.
This is going a while back to what y'all were talking about. My dad passed away a little over 5 years ago. So his name is still on the house. So I guess what you're saying, if my mom tried to sell it, she wouldn't be able to sell it, or would she?
Your mother still living?
Yes.
She can actually go down to the Register of Deeds along with the death certificate. She is listed on his death certificate, and the property can be changed over into her name.
Would it be beneficial to put my name on there?
I don't know and you may have to go through an attorney to have a name added to a deed. Am I right, Marche? But your mother can get her name, the deed changed over into her name right now.
Okay, so this is my mom. So how would we go about adding my name to her house?
You need an attorney to
Need
do
an
that,
attorney.
to change the name on a deed.
Second question. I know someone that had a family member that passed away, and it's been about 6 years, and nothing has been done or handled. Where do you start?
It's not too late. Depending on the assets that's still out there, just go to the clerk's office and say, hey, we have this, we have that. We want to know how to go forward. And that's what we're here for. We're there for,
Okay.
just to assist with that process. Like I said, we're not attorneys, but we can give you the steps and the paperwork you need to get started.
Okay.
So it's real simple. I mean, it may be a process, so don't get frustrated. We always say, seek legal advice if it gets to be too much, but we are there to assist.
Okay, so that would be you said the estate department. It's
in-
Gaston County, so
Clerk's office.
clerk's office. Okay.
Now, I would suggest it's going to take some time to actually get an appointment in there because we're still working from COVID.
Okay.
So go ahead now, get the paperwork and get you an appointment scheduled to be seen and get it processed.
Okay.
Any other questions? Yes, ma'am.
The medical power of attorney. How is that? Because I'm not sure if it's in our will or not. I can't remember. So,
It's not part of the will. It's a separate
Okay.
document.
okay. So how do you do it?
First, it must be filed. You want to have it filed at the Register of Deeds.
No, she wanted to get it done
Oh,
first.
she want to get it done.
Yeah.
It's not done.
No,
Okay, yeah.
I think we did it at the hospital, but it was years ago.
Where are you keeping the document that you did at the hospital years ago?
Please.
No, no,
I know.
So we can talk. Okay. I want to give, we got 10 more minutes. Want to give Minister Dawn a second. She wants to talk to, I wanted her to talk a little bit about her experience doing probate in South Carolina. Can you grab that mic there, Minister Dawn? And then after her, I wanted to give LaTron an opportunity to speak.
Good afternoon. I'm gonna, I heard you, Plato. I'm gonna be as brief as I possibly can. Once again, good afternoon to everyone. For those that do not know me, I am Dawn Johnson. I'm one of the servants here at Center Baptist Church. I'm also part of this team of people that are, thank you, team of people that's trying to provide different workshops here at Center. I am going to talk just a little bit about the South Carolina process for probate. You may hear me refer to Lady Rosalind Crawford if I forget something. The reason I do that is because she has been with me through every part of the process. So my father died August of 2022, and he died without a will. Now, once again, I just want to say that I'm only telling you my process and my experience, because every process and everyone's experience is different. So he died without a will. And once I got the information, because I hadn't seen my father in years. And so once we got the information from the coroner's office, we had to go to York County Courthouse. And the first thing we did, we had to get an affidavit for me to be able to go to the bank, go to Wells Fargo, not to access the account, but to get the balance of the account. Is that not correct? We had to get the balance of the account. And the reason I did that is because I needed to know if he had some money to take care of the things that he needed to take care of. So once we did that, then everything just started happening back and forth. It was time to plan a memorial service. My dad had to be cremated because my dad died in the house and was there for a while, and his body was badly decomposed. So we had to do a memorial service. We got to the house. We were able to get vital information as far as what type of bills he had, things to that nature. I did know that there was a brother. I had never met the brother, never seen the brother. I had to find the brother because at this point, there are two heirs to my father's estate now. Okay. You hear a lot about, the heirs, what happens to the property, probate. If once again, if you don't have a will, which is really beneficial for you to have a will, but if you do not, it is going to probate, and the heirs, they're going to look at the heirs. If there's no husband, wife, or whatever, then they're going to start looking at the children. So there were two. I have a brother in Texas. And so basically what we had to do, once I found out there was a brother, once we got vital information that we needed, I had to get an attorney because I don't know anything about this process and the probate. Now, some are going to say an attorney is expensive. Yes, they are. But I'm going to tell you, if you can find a way to pay for an attorney, it would be better for you to get an attorney because they have been to school, they know all of the laws, and they can help you navigate through this process because you're about to go on a ride, okay? And I'm talking about how South Carolina works. So once we got the attorney, once I found out that there was money in the bank, the next process was I had to make sure because he had a house and he had a car. I knew I was not keeping the car, had to get rid of the car. But I knew we would have the house, decide what we were going to do with the house because that's the biggest asset. And there are bills. So you know that if you've got that largest asset and you know that there needs to be things that need to be paid for, so now you start thinking, well, this house is going to have to be sold. Okay. But before we got to that process, I had to make sure that the house payment was paid for so that it wouldn't go in foreclosure. So guess who's paying for that? I had to pay for that on top of my own bills. Okay. That was a $742 expense that one day I went to bed on a Friday and woke up on a Saturday, and now I got a house that I've got to pay for. Okay. I had to pay for that. I have to keep the lights on in the house. I was not concerned about the car. Because I knew we wasn't keeping the car. So once I got the attorney, once we got with the attorney reached out to the other heir, the brother, and he started the process with him. He started the process with me. There's a lot of paperwork that you're going to have to sign. And when I say a lot, I've got a folder at home that looks like, I'm only 10 months in. It looks like, that folder looks like I've been doing this for 5 years. You've got to keep up with every piece of information. You've got to keep good records, because the court is going to want to see what you have been doing, and they want to see proof of what you've been doing. Okay? So bottom line is this. We went through, we got all the paperwork done, got all that done, got the service taken care of, everything's being paid. Now, we had to open up an estate account. My dad passed in August. We had to petition the court. Everything you do, you're going to have to petition the court. Okay? Everything. Because now that he didn't have a will, everything belongs to the court. Okay? So you've got to get permission from the court. You can't just do whatever you want to do. You can if you want to, but I won't advise that because it's not going to go good for you in the end. So we got the estate account. He died in August. The estate account was not set up until October, November. That's when it was set up. What does that mean? That's when I had access to my dad's money. I was able to have access. Okay. Did I have access to go do whatever I want to do with it? No. I had access to be able to handle his affairs, whatever needed to be taken care of. And so basically, whatever I had already spent, I had to get permission from the court to reimburse because I was made let me back up. I was made the personal representative. My brother signed off on me being the personal representative because that's what they call it in South Carolina. What does that mean? That means I get to make all of the decisions with my attorney and with the approval of the court. Okay? And so I was able, once we got the estate account set up, I was able to get reimbursed. I have a checkbook that has my name on it. It has the estate of my father's name on it. And anytime you will sign a check, and I'm talking South Carolina, anytime you sign on the dotted line, I will have to put my name, a comma, and PR, personal representative. Okay? So I was able to reimburse myself whatever I had already spent out. Okay? So that got taken care of. What happened to the car? He still owed a note on the car. The car went back to the dealership. The car bought the car from the estate. They paid me a check. They paid off the loan, and they got a car that they can resell. Okay? And what happened to that money? It went in the estate. Every piece of money you get goes into the estate. And you have to have copies of the bank statements. My attorney asked me for copies. He asked me for copies all the time of stuff. Okay? Now, fast forward all the way up. We passed 2022. We get to January, February, and March. Guess what? My dad's smell and fluids are still left in the house. There's no way we can sell a house with that dead body smell in the house. So now it's, what are we going to do? Check the insurance policy on the home. Because guess what? They had to pay to get the smell out of the house. Okay? Now that house has new floors, new subflooring, has a whole, all the walls had to be painted. All the cabinets had to be painted. I think that was all that was new, right? The cabinets, the walls, and the new countertops. Now somebody might say, what in the world? That's what we had to do to get the smell out of the house. Okay? Because the fluid seeped through the floor and the smell got in the wall. But guess what? Did the estate have to pay for that? No. The insurance policy paid for every bit of that and reimbursed, praise God, reimbursed the general contractor for the work that he did. Okay? So now where are we in this process? May the 24th, guess what? We had to go appear before the judge. Lady Rosalind Crawford, why did she have to go? She is a real estate agent, and she's got her license for North and South Carolina. So the house now is in probate and it needs to be sold. So myself, my attorney, and Rosalind Crawford, we had to appear before the judge. And that is one experience that I don't ever want in my life again. Not that the judge was mean, because she was not, but they will question you about everything. They questioned her more than they questioned me, because they wanted the information about the sale of this house, how much it was being sold for, and everything. Okay? So I want you guys to know it is very, very, very important. When you leave out of here today, I'm going to urge everybody in here, before you do anything else, get your stuff in order. Now, I'm being serious. Get a will. If you got loved ones that you say you love so much and you care about, please do that for them. Don't leave them without a will. Don't leave them without life insurance. Now, my dad had life insurance, but guess what? Was I the beneficiary? Absolutely not. No, I was not. So that's why I said money came out of my pocket, and it didn't come at a great time, but things had to be done. So now to this day, the house is on the market. We sold the house in 72 hours the first time, and their funding fell through. So now we are live again. We do have another offer, and we're closing out bids on Sunday at 3 o'clock. Is that correct? Now, what happens after that? Is this process over? Nope, it's not over. Because now, once we sell the house, the money will go in a trust at the law firm. That's where the money will be. They will handle that. And we will, and I believe it has to be held in South Carolina for 30 days. 30 days. And we will continue on this journey of making sure that everything gets taken care of. Now, let me also say this. There are some creditors that will just close it out and that's it. They're done. They won't ask you for money. I've had several of them that have done that. They haven't asked for anything because it's not my debt. It is the debt of the estate, but they closed it out and that is it. Now, I believe one of you said something about the taxes. My tax preparer is in here today, and I had to get my dad's taxes taken care of. So you have to do that process as well. So I hope this information, I don't think, was there any vital information I left out? Y'all, this has been a journey. This has been a lot. And it's been a lot for an individual that had nothing to do with me and that had nothing to do with my brother. But guess what? God is amazing because forgiveness is important. Start forgiving people. I'm able to walk this road and do what I'm doing for my father because I forgave him before he left this world. And I want to be able to share with others the importance of forgiveness and loving one another, especially those that don't love you, that don't love you back, that don't put it in motion back. It's okay. All right? So I hope that helped. Sorry, I went over the 13 minutes or however long, Plato, 3 minutes, excuse me, sorry. But people need to know the process. That's why on the flyer it says, life happens after the benediction. Life happens. We can come in here in these four walls. We can shout. We can worship. We can praise God. We can do that because when we walk out the door, that's when stuff starts happening. And you're going to need the word of God to be able to get you through. And you come and you praise and you worship him because you saw how he brought you through. Amen. Come on, Latron, close us out.
I was sitting there looking for Devon on the organ on that one. All right. You guys had a good time? I mean, it's a lot of good information. This is a lot of stuff that we need. I am not, can I close this out? I'll give you this. This is something that I have not had a lot of experience in. I had a little scare with my dad about a month ago. And, I was really scared, wasn't really sure. My dad's a big part of who I am. And, it would have hit me hard. But then, I realized and I always knew that, I didn't have all of his stuff together. He had a lot of it together, but I didn't know where it was. And I'm the oldest, of three children. So, several of the sentiments that were passed today were, making sure you got your stuff together, to quote Minister Dawn. Also, there's other things that we don't think about, like, these passwords that are out there for these online accounts, since everything is out there, making sure that you know where everything, all your documents are created. Sister right here, you said, what was the name of the book? My Will and Testament? My Last Will. There's tons of resources out there. Sister Marche, she passed out this estate planning questionnaire, and it has all of this information, several pages of information that you can get started with in getting your all of your items, your documents, or at least just get some information to get you started. I am, again, this is not my forte. I surround myself with people that know. I like Pastor say, I know how to run in my lane. But I do also, it doesn't matter what you have, what you get, but you need to get something. I have a good friend of mine. She's a insurance agent, but she's also a licensed notary. And she has this book that she's been preparing for her clients, says Life Matters, Directives and Documents Regarding My Medical, Financial, and Personal Affairs. And, you know, she has tons of stuff. And I told her I wouldn't try to speak it on my own, that I would read her commercial. So if you just give me a couple minutes, basically, are your important documents, life insurance, birth certificates, lease, deed, will, power of attorney, etc., in a place that are readily available? Does someone other than you know where your important documents are located? If you were incapacitated, seriously ill, or passed away yesterday, what would your loved ones be doing today? These are all valid questions, and while having these conversations may not be as exciting as planning a vacation, choosing the next family barbecue, or celebration, they are an essential part of ensuring your affairs are known or at least readily accessible for you and your loved ones. This helpful planner we have here is the binder, leather binder, organize all vital details about your contacts, your financial health, your legal and personal affairs, all in one place. In addition to having this planner as a personal organization resource, this planner should be shared with your loved ones, and that's key, your loved ones, family members, personal representatives, or those who would be responsible if you are sick, incapacitated, or upon passing. This particular planner, and again, you can use anything, but the information is valid. So the planner that you choose should have information regarding your caregiving document organizer, your checklist, your sample filing system. We have tab sections covering your health insurance, beneficiaries, health records, identity records, income sources, legal documents, life insurance, passwords. Again, a lot of people have stuff online, 401ks and all that stuff, and phone contacts. Now, again, you can get anything. The book, do you remember what the cost of that book was? Yeah, I mean, this stuff, you know, you could do it on your own. You got a free one right here from Sister Marche. Thank you, Sister Marche. But you know, there's some that have a little bit more information than others. You can put it together yourself. She's selling this book, you know, for $50. It's a leather bound book, and it has various sections in here for various things: medical power of attorney, all that stuff. But it's very important, regardless of what you use, that you get something to keep this information in. Because the last thing you want to do, if somebody dies, you're, you know, scrounging around to try to find, look in drawers to find things, or as Pastor said, look up under the bottom of the third drawer in the cabinet to find stuff. You want to be able to put your hands on it immediately. And, you know, it's up to you. You could even have multiple copies, you know, put somewhere. You can put it in a safe deposit box, make sure somebody has access to that safety deposit box. But it's very important to have this information. And I think that's one of the big keys. You know, everybody knows, oh yeah, you need a will, right? You need a trust. But where is all that information gathered, right? And who can get to it? I think that's some of the big things. So again, want to thank everybody for coming out. I think this was a very informative session. Definitely want to thank Miss, make sure I get your name, Tressa Hood. Thank you so much. Also, Marche Stevenson, thank you. I have learned a lot. I was sitting over there snapping pictures of the slides and stuff. I'm gonna definitely have probably more questions for you guys. I'm in South Carolina. I'm not North Carolina, but I'm sure, you know, you can help me with some questions. All my questions are easy. Yeah, all my questions, because I'm a newbie. So as for your questions, this was great. Again, this is just one of the workshops that we're having here for the CBC Economic Development Division. We definitely need your help. We need you guys to spread the word. This is what we're doing for the community. These sessions are free. And you can also find the sessions on our website. That is cbcgnc.org, where you can find out what other sessions that we're going to have. And yes. Yes. So the next session, I was actually going to do that before you raise your hand and interrupt her. She don't give me much credit, but that's all. I love her anyway. No, so yeah, but she's right. Our next session is July the 15th. And it's 10 a.m. here. We're going to be discussing life insurance And I think we're going to have someone from a funeral home coming as well. And so I definitely want to hear, because I'm sure they're going to have a lot of information to give. So so what do you guys think of this session? Good? You want to see more of this stuff? All right. So again, we need your help. We need your support. This is all information for the community. Please spread the word. And are there any other questions, announcements? Thanks, Sister Rosalind, for being here. She's one of our team committee members. And also give it up for our leader, Minister Dawn Johnson. She's always keeping us straight. I know she's trying to keep me straight all the time. Also want to give it up for our media ministry, Brother Robbie, Sister Megan back there. A lot of times, those are the quiet heroes in the back. Nobody knows their name if they're doing a good job, and they're quietly doing their job. So we definitely appreciate them. For all hearts, minds are clear, we're going to go ahead and close out. Dear Lord, we'd like to thank you for this beautiful day again. Thank you for this session, Lord God. Thank you for the information that has gone forth, Father, regarding estate planning, wills, and making sure we get all of our information together for our loved ones. Father, we know that at one point, one day in the future, you're going to call us home, and we want to make sure that we have things squared away so that our loved ones can just be able to rejoice in our celebration of life and not have to worry about the issues regarding after death items. Father, we thank you right now. We just ask you just to be with everyone on their way to their destinations as they leave this place. And Father, just continue to instill in us a desire to learn more about how we can better our lives financially, as well as being able to get things in order for our loved ones. Father, we love you, we bless you, and we magnify your precious name. Amen. Thank you so much. Have a great day. Oh, and if anybody is interested in this book, you can come by and take a look at it, or if you're interested in purchasing, just let me know. But hopefully you'll be able to pick up something to help you get your affairs in order. Thank you.